Welcome to Court Explainer from Court Helicopter, where we are dealing with the questions of tenants and landlords. We'll also expand this question further as we proceed. Have you ever been told by the landlord, you cannot bring male friends to this place? So your boyfriend or your fiancé, you can only meet outside in Java. Have you ever been told that as a man, you cannot bring women friends who are wearing trousers or miniskirts to this place? Have you been told by the landlord you can't play loud music and you're paid rent? Have you been told that by clauses that you can not hold a bash in a house that you're paid for rent? Have you been told how to live in your own house that you have paid for? Have you been told that you can't come to this estate beyond 10 p.m.? The door is locked. You can't access your own building. So all these questions that discriminate like this, have you been told that in some estates you can't drive there a Probox, or you can't come with a Vitz because it devalues the value of the estate? Have you been told in some areas that you cannot be dropped by a border? You are left outside there, you walk in. It is raining, it is muddy. The rules don't allow you to do that. What is the law about these things that are hurting people all over? It is called the right to admission. The laws that deal with there, we look at them. So the question that first comes in, you'll have some landlords give you a lease, a document, and they have specified what you can't do. My good friend told me she loves keeping a small cat, but she was told no animals, no pets around here. Who should control what you do? So that agreement, if it is drafted that way, what is the law? And we start with the Constitution of the Republic of Kenya. What does it talk about those issues? Article 27 of the Constitution, which talks about the equality and freedom from discrimination. So the question is that not discrimination? Yes. You can challenge that decision of the landlord that it is against Article 27, which says every person has the right to equal treatment, including equal opportunities in every social sphere. So anybody telling you can't come with your girlfriend or your boyfriend or your colleagues, or you can't put earpiece when you want to be in your house, you don't do those things, it is unconstitutional against Article 27. 2, Article 43 provides for economic and social rights. That's what I'm saying. You have social rights that you enjoy your freedom as a human being. So the landlord cannot restrict to you. It also talks about Article 24, the limitation of rights. It specifies that rights, including any right, can only be limited by law, and to the extent that it is reasonable and justifiable in an open and democratic society. Is it for you to say rights of admission No woman allowed here. No man allowed here. That one is against Article 24 of the Constitution of Kenya. But general principles on rights for the properties that are private. Here, now you understand why sometimes your rights must be restricted when it comes to private properties. What does it say? Private property rights. While public institutions are bound by anti-discrimination laws, private entities often reserve the right of admission based on security, public health, safety, or other non-discriminatory policies. So the landlord is right, for example, to say no border borders should pass here because of theft. For security, they can put restrictions. But as I've said, the restrictions must be reasonable and be justifiable. For example, you go to some clubs, hotels, and you find a notice, the management reserves the right of admission. The law protects that. For example, any child below 18 years cannot be allowed into a bar. Management can tell you, walk out, you are a nuisance in this place. If you play loud music and you are disturbing your neighbors, management can throw you out of a gated community. So this question is both sides. If the private owners or the landlords are doing it for the bigger good, public good, the landlords have a right to restrict you from smoking opium, from taking changa, from doing illegal acts in the house. It is justifiable. But the management has no right to tell you who can be your visitor and what time does your visitor come. Management has a right to enforce the NEMA Act of the level of noise. If the noise disturbs neighbors, then you can be removed or be denied the right to do those places. So it is not an absolute right for management to give policies that are anti-community, and also the tenants, you have an obligation to make it. For example, your neighbor turns their house into a drinking place. People are drinking, they get drunk, they forget that the urinal and the small houses are in the house, they start all over doing things that a court helicopter cannot tell. And children are there. Management has a right to maintain morality, and therefore, as a tenant, you equally have got to assess, is it what you're doing legal? Is it justifiable? Is it morally good? Does it show decency? Does it show that you respect others? If not, then the management or the landlord has a right to remove you.
Does the law allow the provincial administration, chief wa kijiji, to come and deal with the matters of rent? Have you chased that chief and you find yourself in problems? The answer is the law allows the chiefs to act on issues of rent, but the house, the chief has only power if rent is not more than 200 shillings. If rent is below 200 shillings, so these are the people in the slums, if you know your rent is below 200 shillings, the area chief has power delegated to him by this act called the Rent Restriction Act, Cap 296. How does the chief come in on these issues? One, in this act that is provided for in this act, that is section 5 sub 3, it says, in respect of premises whereof there is no standard rent, or whereof the standard rent does not exceed 200 shillings a month, the tribunal may from time to time delegate all or any of its powers under this act to an administrative officer or any other person. So, however, that no such officer or other person shall be authorized to assess the standard of that. So what we are saying, if the rent is below 200 shillings, you don't take that matter to the rent tribunal. That matter, the chief has been delegated power to resolve that matter. So now you know. That's why you hear in the villages where the slums are, where rent is below 200 shillings per month. I know very many Kenyans will be shocked that there are people who pay rent over 100 shillings, 120 shillings, 180 shillings. There are those ones who pay 50 shillings for rent. So those you don't take that matter to the rent tribunal. The local chief deals with that matter. And the act provides that the decision of the chief is final. So the question Wakili Danstan Omari is asking, the local chief might be a relative of the landlord. Will you get justice? The local chief came to a place to take a glass of changa. You denied him on credit. He must pay. Is this not a loophole under the law? Ask your members of parliament. Me, myself, I don't agree that the local chief should be given the power of a magistrate or of a court to decide disputes of rent. I know the chiefs do a lot of work, but for now, that is the position of the law. So, we have answered what you have always been asking.
But as we have said, any clause that is illegal, that is unconstitutional, will be challenged at the tribunal. It can also be challenged in court, and the courts will always protect the tenants against the landlords. Wakili Danstan Omari.